Good afternoon to you all. My name is Nkanyiswa Gumede. I'm a researcher at PLUS. Today we are discussing the upgrading of Land Tenure Rights Amendment Bill of 2020. This bill is an amendment of the upgrading of Land Tenure Act, which was passed in 1991. The Constitutional Court recently declared it unconstitutional and instructed the Parliament to amend it. The Portfolio Committee then invited the public for comments, and then submissions were made by different organizations. Then last week, on Tuesday, the department responded to the comments. Today, we would look at the origins of the Act, its objectives, the extent to which it has been applied and where, and we'll also look at why it is being amended, and then we will finish by reflecting on the response by the department. Our overall aim for today's webinar is also to contribute towards the debate on tenure reform and the best way to secure land tenure rights, particularly for those with informal land rights who are said to make about 60% of all South Africans. So to help me with the discussion, we have Rosalie Kingwill. She is a research associate at PLUS and a member of Landness. She has done work on land governance and land administration in rural and urban contexts. Next, we have Nwanda Sihlali, who is a research officer at LAC at the University of Cape Town. She does work on tenure security in the communal areas. And last but not least, we have Mr. Kanyeza from Dinabagubo community in KwaZulu-Natal. Welcome to you all. Before we begin with the discussion, I would like to remind the audience that you can tweet the proceedings using the hashtag #LandRights or hashtag #LandTenure. Please also leave your questions on the comment section, and then the panelists will respond to those questions. So my first question will be directed to Rosalie. Rosalie, could you kindly please take us through the origins of ULTRA, its objectives, and the extent to which it has been applied and where? Over to you, Rosalie.
Oh, thank you, Nkanyiswa, and yeah, welcome to the viewers. So the upgrading of Land Tenure Rights Act of 112 of 1991 is a pre-constitution act. It was passed in the dying days of apartheid. Still 30 years later, still on the statute books. And it's one of those acts that we have to understand in the context of the time in which it was passed. It was one of a suite of laws that was passed at the time, and mostly after the abolition of Racially Based Land Measures Act, you know, when there was a panic in the apartheid circles to start liberalizing land tenure and land access. So it was one of three at the time. And a very important one to bear in mind, because I will come back to it, was the Less Formal Township Development Act 113 of 1991, which is a planning law. It was passed at the same time. So because of restrictions on time, I'm going to divide the talk into sort of four sections. And the one is covering the early 90s, sort of when it was first passed, which I've partly covered. Then we'll move to the mid-90s when, you know, the white paper was formulated for land policy, and then look at the late noughties, and then a little bit coming closer to the present. So ULTRA, you know, is a conversion law. It's a little bit of a misnomer, but that's a debatable point we'll come back to call it upgrading. But it's essentially a conversion law that converts one type of tenure to a different type of tenure. And the law made provision for two groups or categories of tenures that could be so-called upgraded. And the distinction was carried in the Schedule 1 and the Schedule 2. And the Schedule 1 were automatically upgraded just by the stroke of a pen. Because those tenures were already surveyed. The critical issue was the survey. And essentially those were the deeds of grant, quit rent, which was prevalent in the Transkei and the Ciskei, to some extent elsewhere. And then the deeds of grant in the urban townships and some leaseholds. And then the Schedule 2 were the unsurveyed rights, which were the PTOs. And then there was a strange add-on, this tribal land, which Nakwanda will mostly speak into. It's a little bit of an add-on. Now, at the time, I was working in the NGO sector. We were very involved in on the ground. We weren't involved at all in the legal side. And our understanding of this act was really, it was more aimed at townships. It's mainly intended for the townships because they were already ready to go. And then the quit rent was a very strange one because we were working on the ground and we realized that quit rent is a very, very odd hybrid. People have customized it. And it is not at all easy to change quit rent into freehold, although it might sound like it's easy on paper. And in fact, indeed, on paper, over time, as the TBVC states have been brought into the Act, they have literally just been upgraded on paper, like in Mthatha Deeds Registry. If it was lot 54, it's now F54. But on the ground, absolutely nothing changed. So we were very concerned about that aspect. But as far as the township's concerned, there was very little resistance. It was pretty much the way things were going. And so we understood the Act to be basically to get rid of two notorious proclamations called R293 of 1962 and R118 of 1969. There isn't time to go into these. Some people will recognize them. But these, what's important to remember is those two proclamations governing tenure in urban and in rural areas were themselves consolidations of previous laws. It went all the way back to the 19th century. Many people thought it started there with the apartheid, but no way, it went all the way back. And over time, they got more and more entangled, more complex, and eventually the apartheid government decided to try to consolidate them into one. And then it was also an attempt to harmonize the Black Community Development Act 4 of 84 and another leasehold law of 88. So the important thing that I'm trying to say that there's actually a great variety of tenures behind the scenes, but on the surface it looked like just these two kinds. There's also a add-on, which is the Land Titles Adjustment Act in 1993, 2 years later, because it was realized that registers fell out of currency very, very quickly. People got their title and then didn't upgrade them. Didn't register them in the transfers in the deeds registry. So we were very concerned about the mismatches. Because in quit rent areas, for instance, people held on to the customary notion of family property, where one single person shouldn't be in the register. You could you could sell the property out from under the feet of the families. And quit rent did curtail sales. Although it was a form of title, and we had noticed over the years that registers were chronically out of date. Then let's just come to I'm sure I don't have a lot of time left. I'm going to have to gallop through the last bit, the second bit. So in the mid-90s, the white paper essentially endorsed ULTRA, but it made 5 amendments to bring it in line with all the changes and reorganization in the department, new names, to make it much more, conducive to the Constitution. The minister's powers were changed from shall to may and so on. So let's just look at what happened in practice. In practice, ULTRA proved to be extremely difficult, costly, and time-consuming to apply. And so much so that so little progress was made that in 2009, I must start winding up, the Department of Land Affairs commissioned a major study to look into the application of ULTRA. It's a massive document, 200 pages is the overview, and then it's got all sorts of fascinating data and appendices and maps. It was a very, very thorough and rigorous review, and it came to the conclusion that and it looked at 5 case studies in depth. Mgwali and Mdantsane were the 2 Eastern Cape ones, and it found that Mgwali had taken 12 years of intensive work, had got nowhere, they abandoned it, and Mdantsane took 10 years, it still wasn't completed, but that was fairly successful in the long run. So that is my so the application was R293 and R188 essentially.
Okay, no, thank you very much, Rosalie, for that brief history. What I gather from you is that the Act has actually failed to live up to its objectives, but we are going to engage further during the Q&A session. For now, I would like to bring in Nokwanda. Nokwanda, can you take us through why is the ULTRA being amended currently?
Okay. Thank you so much, Nkanyi. So my name is Nokwanda, as Nkanyi has introduced me. So I'll just be taking you guys through the reasons why ULTRA is being amended, the contents of the amendment, and the likely impact. So this is something that we said in our oral submission, that the bill is good. The objective of ULTRA is to allow certain rights in land that were systematically weakened and undermined by the apartheid government to be upgraded and converted into ownership. This, as Rosalie has mentioned, was a pre-constitutional attempt to reform the tenure framework to which Black people were limited. Because of the Rahube judgment, Section 2.1 of ULTRA is declared constitutionally invalid insofar as it automatically converted holders of any deed of grant or any right of leasehold as defined in Regulation 1 of Chapter 1 of the Regulations for the administration and control of townships in the Black areas into holders of rights of which rights of ownership in violation of women's rights in terms of Section 9.1 of the Constitution. Because 2.1 was declared unconstitutional, conversions of tenure rights will no longer be automatic. The amendment bill now provides that potential rights holders make an application to upgrade their tenure rights to the minister for consideration. However, the proposed amendment of Section 2 of ULTRA raises a number of issues that need to be dealt with before the adoption of the bill to ensure constitutional rights are not violated. The amendment bill seeks to insert Section 14A, which provides an opportunity for persons aggrieved by conversions that took place from 27 April 1994 to approach the courts for appropriate relief. However, the cost and resources that are related to approaching a court for any form of relief means that courts are inaccessible for a vast majority of South Africans, particularly the poor and marginalized persons to whom ULTRA mostly applies. A more accessible, possibly community-based process is required that can appropriately take into account the resource limitations South Africans struggle with. After fully considering the implications and operation of Section 3 of ULTRA in the Senqu municipality matter, the Constitutional Court declared Section 25A of ULTRA unconstitutional because Section 3 was not applicable to the entire Republic of South Africa. The Senqu municipality matter involved a permission to occupy certificate issued to the Teba Property Trust in respect of a piece of land falling under the Senqu municipality located in the Eastern Cape province. The Teba Property Trust made an application to have the PTO certificate converted into ownership in terms of Section 3 of ULTRA, and the municipality rejected the application because Section 3 was not applicable in those parts of the Eastern Cape, which were under the former Transkei homeland. Teba Property Trust then approached the court and argued that the non-applicability of Section 3 to former Transkei areas was unconstitutional because it infringed on rights to equality and the right to equal protection of the law. The court concurred and ordered that the section be declared unconstitutional on the basis that it did not apply throughout the Republic. In addition, Section 14A was inserted to give effect to this court order and Section 25 to make Ultra in its entirety applicable throughout the Republic. However, the amendment bill goes further than the court's decision. Section 25A of the Act has been amended to provide that in addition to Section 3 of Ultra, Sections 19 and 20 also apply throughout the Republic. In doing this, the committee must then also proactively, thoroughly engage with the history, the operation, and the implication of Section 19, which deals with the legal capacity of a tribe to obtain property, and Section 20, which deals with the transfer of tribal land to a tribe. Our advice to Parliament was that they should thoroughly consider the appropriateness of Sections 19 and 20 and their implication for constitutionally protected rights in Sections 25(6) of the Constitution. Thank you, everyone.
Okay, no, thank you very much, Nokwanda. From that presentation, I gather that the amendment of this act or the introduction of this amendment bill is just to deal with the gender discrimination that came with the bill, but we'll reflect more later on. And now coming to you, Mr. Kanyeza, you are from a community that has been affected by Ultra. Can you please take us through how you have been affected by Ultra as the community? Over to you, sir.
Okay. Thank you, Kanyisa, and good day to everyone. Yeah, I will give you a lived experience account as victims, which pertains to our land dispossession. So I will start here by saying the construction of Inanda Dam in the 80s necessitated removal of affected tribal families involving Ngolosi, Kati, Mapepeteni, and Gwanyuswa tribes. As part of compensation to these affected tribal communities, payments were only made for crops and structures, but compensation for land loss has been a subject of much contestation, as it is known that people in tribal areas don't have a security of tenure. Only permission to occupy is issued by the tribal authority. However, in the case of my community, which is one of the affected desert tribal communities as a result of the construction of Inanda Dam, land constituted a major compensation package. That is, about 322 hectares of land was set aside as compensation for this affected community. Land, part of this, 250 hectares for agriculture, and then 72 hectares for residential purposes. The 250 hectares of land was transferred from Land Affairs to Ngolosi tribe in 1994, which we believe was held in trust for the affected families as compensation. 72 hectares remained with the Department of Land Affairs for residential purposes. But subsequently to that, because the chief had as a custodian of these pieces of land, so we learned that 250 hectares was sold to the Tegui municipality, and then the amount that is reflected on the title deed is about 3 million. And as a community, we were not informed about these transfers. And there are other various transfers that also took place, but I just want to mention this 250 because it's the one and the most, I think, the sizable piece of land that was sold without us being given the opportunity to voice our opinion. So hence, as the community, we are concerned with this amendment that is going to actually bring about the necessary balance between the exercise of power by the traditional council, as well as we as the community, the rightful owners of these pieces of land. We want to also to mention that as we view land not just as a ground that we stamp our foot on, but it represents our dignity, our identity and culture, as well as the lifestyle. So it is not just a piece of land. There is lots of things that goes with it, because when we removed, there were graves, and then the whole lifestyle of the community was completely disrupted. And hence, today, we want to appeal that as a result, of this new act or bill, it's going to actually address the injustices that we have suffered as the community, so that it will prevent then the traditional council to abuse the powers that they have, and actually bring the necessary accountability mechanisms to ensure that those who exercise power, they exercise it within the prescripts of the law. So that is where we stand as the community chairperson. So we are in support of these amendments, like we said, so that whatever that we have lost in terms of the pieces of land, we hope is going to be brought back to the community and actually be in a position to continue with the kind of lifestyle that they used to enjoy before the removal, because we didn't choose to move from another dam. It was kind of like a forced removal to us. We were promised that when we moved, then the compensation is gonna be made available. But then when that compensatory land is in the hand of the chief, and then they decide to abuse their powers for their own benefit without involving the affected communities. That's a serious injustice, which has actually led us to wake up and actually bring this matter to the fore, as we have done. We bring it we've brought it to the attention of the portfolio committee in Parliament as well. So we are in this struggle to win, because we believe it's not just us. There might be a number of communities which are in the same boat as us. So if we can join hands together and fight this injustice collectively, it is going to help us quite a lot if we actually combine our effort. Because one injustice is if it happens in one community, it's not good for the country. Hence, it's important now we are in support of the new legislation. Thank you so much, Chairperson.
Thank you very much, Mr. Kanyeza. I think your story reflects some of the concerns that were raised in the submission by LAC, where it says that the transfer of tribal land to traditional councils, if it is done without proper mechanisms, it may result to undermining of individual, family rights and group rights. Coming back to you, Nokwanda, is the story that has been shared by Mr. Kanyeza behind the concerns that you've raised about the transfer of land to tribal councils? Because if you look at the department's response, specifically to that case, it says that this is just a failure. It happened because it's just a failure to comply with law by the said traditional council, or it may be it's because of corruption. Do you agree with this? When you respond to this, kindly also outline other points that you raised with the department on your submission and also reflect on their response. Thank you.
Okay. Thank you, Kanye. So you know what? I think I'll just go straight into what I was going to discuss in terms of specifically engaging with the department's response. But also on the 4th of September, the portfolio committee, the staff members actually presented to the portfolio committee, and they were giving their observations of what has happened with the oral submissions. And for me, they addressed very important points which we were disappointed by in the response of the department, because essentially the thing that they were saying, when we say section 19 and 20 are problematic, they're saying, don't worry about it here, we're coming up with the communal land tenure bill. And then the other thing that we're saying is there can be a misuse of this act to actually engage in elite capture. You know, you can have traditional leaders. Not all traditional leaders are bad. That's one thing that I want to explicitly explain, that we have problems in each and every society with each and every sort of governing structure. And so these are just some of the problems which we can face with the abuse of this bill specifically. So if traditional leaders then have the land transferred to them as a community, the portfolio committee is always saying, not the portfolio committee, but the department was saying, it's not going to go to the traditional leader as per se, it's going to go to the community. And we're saying, okay, if it's going to the community, what is the land holding structure? It can either be a trust, a communal property association, or it can be a traditional council. So at the end of the day, you need to have one person at the apex, because we are advocating for exclusive ownership. So if exclusive ownership says one person is going to be at the apex of this title deed, then obviously we're going to have a senior traditional leader having the community's land vested in them. So for us, in addressing our concerns with the expansion of Section 3 and the general applicability of Section 19 and 20 to the former Transkei, Bophuthatswana, Venda, and Ciskei states, the department says, as I'm reiterating, that only 3 out of the 26 sections in Ultra covers upgrading of ownership on communal land. Thus, the need for panic should dissipate as a communal land tenure bill is currently being developed. Although the government has realized that there is a strong requirement to regulate communal land, their attempts at developing legislation to do this has ended in weakening of people's land rights by ignoring the lived experiences of tenure. Some of these disappointing attempts are the Communal Land Rights Act of 2004, which was called CLARA, the Communal Land Tenure Policy of 2014, the CLTP. CLARA was found to be unconstitutional in 2010 in the Tongwane versus National Minister of Agriculture and Land Affairs judgment, because amongst other matters, community consultation was not sufficiently administered by government. So at the beginning of 2017, then Minister of Rural Development and Land Reform, Honorable Nkwinti, announced that the Communal Land Tenure Bill was to be introduced by June of the same year. Nonetheless, this latest version of the bill is also ambiguous and purposefully misleading. In the preamble of the bill, it states that it is determined to provide land tenure that is legally secure, especially in respect of land owned or occupied by communities. However, the CLTP is repeating the same fundamental assumptions as CLARA and the CLTP. The CLTP does not define community in a manner that illustrates innovative thinking outside recycled tribal construct imposed by the apartheid government. By transferring title at a macro level of the traditional community, the bill seeks to trump smaller pre-existing groups who usually have strong countervailing identities and land rights. And this was perfectly illustrated by Ubab Kanyeza's discussion of what has been happening in Tinabagubo. So for us, since the CLTP is seen as a holy grail of dealing with communal land issues, we see it as being problematic because, amongst other things, it doesn't engage with the idea of what community is. And also, as I'm saying once again, that by transferring title at a macro level, so if we're ignoring individual, family, and community level rights, other people can come and say, but there's a mining company, they want to mine on this portion of communal land. We all agree. I mean, the CLTP only needs 60% of households to agree to dispose of a land right. And this one, Ultra just wants a community resolution. And obviously, community resolution will be determined by the majority. So even in there, how do you engage in conversations where you might be an individual land rights holder, but the majority of the community want to dispose of that land right because the title deed is in the name of the community, or as we foresee it, it's going to be in the name of a senior traditional leader or any sort of person at the senior level in the communal property association of the community or the trust of the community.
Nokwanda. From your presentation now, it's actually supports some of the points that were raised by Rosalie in her submission, that actually there are not enough institutions and there is not enough administrative support to assist in terms of making some of that which is expected to be delivered by this bill. Rosalie, please kindly reflect on that, because in your submission, you argue that there's no enough institutional support, and you also argue that the bill itself, it addresses the symptoms, not the fundamental problems that are in the Principal Act. Can you please reflect on that and also reflect on the response by the department? Thank you.
Yes, and Kanyiso, yes, you summed that up very accurately. So in terms of the department's responses, yes, we're extremely disappointed. You know, they've fallen back on sort of two options, because if going through the responses to all the various submissions, they'll either say, no, that will be covered by Ultra, the amended Ultra, or that's going to be covered by the new Communal Land Tenure Act. So it's the very, very binary that we have been, you know, arguing against for decades. So it's going to be communal, or it's this upgraded version of ownership, which in fact has been extremely problematic where it has been applied. So, you know, my argument would be that, you know, if you look at the rest of Africa, you won't, except perhaps Namibia, you won't find the word communal in their land laws. It's customary rights. There are I'm not saying they're perfect at all. There have been problems there too, but we want to recognize customary rights. And, you know, in terms of what Ultra is now, we want that to be simply a conversion law, because conversion is much, much more complex than is made out by the department. You know, the simplicity of just simply going to go and change something into a title is sort of mind-boggling, because, you know, behind the scenes, there's masses and masses and masses of administrative and legal work that has to be done. So I always think of that little quip where it said, you know, when fishes are swimming, what do they say? What do they talk about? And the answer is, it sure ain't water. So the water is what freehold tenure, for instance, swims in. It swims in this massive background law, background set of institutions that support it. It goes into surveying, planning, land use management, valuation. I could go on and on and on. And all of those have to be brought into line before something can actually qualify for freehold, and then it's got to be maintained. The person has to want to do it in that way. But what we actually find is that people don't do it that way. So we're finding that there's some fish are swimming in the fresh water, and some fish are swimming in the seawater, and some fish, there is sort of sometimes a little bit of a crossover of the two. But this is not to revert again to another kind of a binary argument, but the point is we have to take into account different kinds of concepts of land and land holding and the idea of family rights. And the Upgrading Act does really not allow for that. And the reason is, to go back to what Nkanyiso said, we do not have the institutions to do these conversions. And we do not have the institutions to support customary law. It is the state's duty. The state has got the resources to support, to do land administration. At the moment, it's quite localized because of the absence of state support. So we have to come back to how we capacitate the state to develop land administration institutions to support customary tenure, and where people want to convert, to convert. We are certainly not saying no title, don't convert. We're not anti-title. We're saying titles are appropriate in the freehold sense of a title, because people have many different ideas of title. But the customary rights are still widely respected, and to bring them in line with the Constitution, and not to revert to the kinds of processes that we've been hearing here from Nakwanda. You know, you need to develop a whole support infrastructure. So that is principally our argument, and the main thing that we have to change is to the fact that we do not have adjudicatory principles for customary law. You need adjudicatory principles either for conversion, because you need to adjudicate in the family who has those rights and what those rights are and to what. And you need it in customary tenure, to where people want to record their tenure. Many, many people want to record their tenure. They say we want title. Well, they want some kind of a record. So in either way, I think the most important gap that we should be looking at is adjudication law. And I don't believe, if we look at the case studies, that Ultra is a yesterday's law, really. And the fact that it's being brought back is a little bit mind-boggling. You know, it's a little bit, but it has such appeal. It's like saying, to upgrade, it's like saying, you know, yeah, I'll give you a Mercedes-Benz to replace your City Golf. Well, who's going to say no to that? But it turns out that there's absolutely no road network for that Mercedes-Benz. And we compare the land administration system. It's a systemic thing. It's how parts work together. It's not about funny officials wandering around. It's about how parts work together in tandem. You know, and to do that, we need to fill in the gaps, and the gaps are in the processes of adjudication. Yeah, so I'll stop there for now and leave the rest to the questions. Thank you.
Yeah, maybe to follow up on what you've just said now, Rosalie, on the issue of adjudication. The department has said that they are in the process of introducing a land court. Do you think that would be enough to assist with the adjudication before the land rights are converted into private ownership?
Are we going to take? Am I unmuted?
Yes, you are. You are.
Okay. Yeah, I'm glad. Yeah, I'm very glad you asked that, because you know what I mean about adjudication is administrative adjudication, not judicial adjudication. You know, we always have to go to the courts to resolve disputes. But freehold people, they have a whole system of adjudication, which is in the form of you know, the people who, the conveyances who check. When it goes to deeds office, there are more people who check. That is a form of adjudication. If you have a similar, not a similar, but a process that works in these other contexts, adjudication would happen administratively before they have to go to a court, before they get into a dispute. But if they do get into a dispute, there are administrative ways of adjudicating. So I specifically mean it as an administrative adjudication and not a judicial adjudication.
Thank you very much, Rosalie. Now we will go to our questions from the audience. Can we have the first question? The first question is from the Alliance for Rural Democracy. They would like you, Rosalie, to reflect on the cases that you talked about from the Eastern Cape, on how those communities have been affected by Ultra.
Okay, am I unmuted? Yeah. Okay, so I haven't been back in the field, in the Eastern Cape for quite some time. So I'm relying on the case studies that were conducted for this big study in 2009. I was part of that study. I didn't do all the field work by any means. It was a big team. But the two cases that were looked at were Mgwali, which was a so-called black spot, as they called them badly, deprecatingly in the apartheid era, and the township of Mdantsane. Those were the two that were looked at where Ultra really was tried. Mgwali, it was 12 years of intensive work by the Border Rural Committee. In the end, they combined it with restitution. It could not work on its own because the quit renters wanted restored what they lost, because don't forget, with forced removals, all these settlements had to absorb people being pushed off farms and being forcibly removed from urban areas. So you have these layers and layers of overlapping rights in these settlements. So the Mgwali one was a failure. I haven't got an update. I would hope to hear from one of you that maybe things have moved on there. I haven't heard lately. But that one was abandoned at that point. But that was, as I said, a while back. And then Mdantsane took 10 years to get to the point where we evaluated it. And it had a team of top lawyers, land surveyors, conveyancers, you name it, all the private professionals, because 50% of our land administration is done by private professionals. And I spoke to many of them. Many people interviewed them. We did rigorous work there. It took 10 years to get all the different layers lined up to meet the standards of registrability. And ultimately, it was successful. But I can bet your bottom dollar, if I went there back now to check the registers, I would very much doubt that those registers are all up to date, but I hope I'm wrong. So those are the only two I know, but basically it was the Mdantsane was a typical R293 township. This proclamation that proclaimed a township in the apartheid days that was eligible for the Ultra upgrading. And Mgwali was a typical R188, which was a rural quit rent area, but it had so many other layers of PTOs and other customary rights and occupational rights and squatters and you name it, all bundled into one small area. It resulted in very acrimonious relationships there. So those are the only two I know of. The one was relatively successful, the one was a complete failure in the rural context. And the same, what I would just like to quickly mention is that the people who were interviewed who did these upgrades, there was a case study in the Free State, in Mpumalanga, Northwest, Western Cape, and these two in the Eastern Cape. Many of them said we could rather use our planning laws. We don't actually need Ultra. You need Ultra for some technical reasons, like getting rid of a servitude or something. But they prefer to use planning law, and Lefty, the less formal Township Establishment Act, was the favored way of formalizing townships, not Ultra. And in one province, they said they didn't want to use Ultra, they used provincial ordinances. And in many others, they said, they could use other laws. So, it's even more strongly the case now because we have the Spatial Planning and Land Use Management Act, it's a planning law.
Okay. No, thank you very much, Rosalie. Let us go to our next question. Our next question is from Constance Mukhale. She'd like to know, how do we guarantee equitable access of the commons in our law? I don't know if Nowanda, you could respond to that. How do we guarantee equitable access of our commons in law?
Okay. So, Kanyisa, I don't think I'm the perfect person to answer this specific question, but in general, I think in terms of the types of laws that need to be developed, they need to be developed in conjunction with what is happening on the ground. So this is something that Rosalie has emphasized, that whatever is happening currently in the communities, those are the ways in which we can dispose of a land right. Those are the way in which we give land rights, and those are the way we administer in terms of land governance, land use, and land management of the community. So even the commons and the things that are the spaces that are shared as a community will be governed by all of us in a sort of, this is the assumption, is that they always have to be underpinned by democratic principles. So in terms of just making sure that equitable access is guaranteed and no spaces are denied, we have to understand also what are the meanings that are given to those spaces, because even in any sort of community, certain spaces are reserved for certain rituals and for certain things that will be happening at the time. So in terms of securing and engaging with what are the individual, the family, the village level, the community rights that exist in the community. Already right now, if I can give you an example, if I go to Makasaneni, even though there may not be necessarily a title deeds that have been registered, because the main thing is rights are there. They are recognized according to customary law. They are just not registered at the deeds registry. And this is what Ultra is centrally about. So if you go to Makasaneni and you ask questions about, okay, so there in that particular Nsimi in Lapano, what happens there? In those rivers, what happens there? People are able to tell you and inform you in depth about the spaces and what they mean in connection to each other, because land is also relationship based. It's underpinned by social meanings. It's in as much as government consistently, from the analysis that you can see from the National Development Plan, land is always a productive element for government. But we have to also take and be cognizant of these things, because land is not only social in the rurals out there. Land is social here in Cape Town. If I was to decide to go and find titanium, on UCT grounds, do we really think I would be out there and speaking to the VC and saying to her, I need you to move? People would fight me, because they would say, that is significant land. It has social meaning. It has cultural value. So we can't necessarily just deface that type of land because of the many layered meanings that it has. So this is also what we're trying to say when we're saying moving into spaces, especially in the former Bantu stance. These are the things that we need to take into account when we're designing laws that have to be cognizant of what is happening. IPILRA is one of those laws. I mean, I know that the department did respond and say, no, don't worry about IPILRA. We have I think it's a land tenure bill coming, so don't even worry, we're going to repeal that. And then the staff members did say, okay, you're going to repeal it, but you haven't presented it. It's only when people have given oral submissions and outlined problematic areas is when you're coming back to us telling us about regulations, communal land rights tenure bill, you're telling us about a land bill. But these are not things that were thought of sufficiently, obviously, as we can see with the response from the department. So I hope I've managed to cover it a little bit in sort of highlighting all these other elements. Nkanyisa?
Yeah, okay. No, you did very well, Nowanda. Thank you very much. Now we will go to our next question. It is directed to Mr. Kanyaza. It's about whether you've been affected by the Gunyama Trust element. I guess this would be about the reports where we've heard that people have had their land rights converted into leasehold. Have you experienced such? Mr. Kanyaza, thank you.
I would say, yeah, well, then the pieces of land is that are part of our own experience. they do not actually involve in Gunyama Trust, because when those pieces of land were released by the government as compensation to my community, they were released in the hands of the tribe. So the title deeds in questions they refer to the tribe as the title holder. So then those pieces of land they were not transferred into the Gunyama Trust. So hence, when we are dealing with this matter, we are not actually engaging the Gunyama Trust. We are engaging the chief and his council directly to asking questions as to how these things could happen without the consent of the community. So we understand there are other communities where a similar injustice has actually taken place, that are residing in Gunyama Trust land, that are involved in the same struggle as us. So, but in our case, it's a bit different. But in context, I think there is some similarities here, because we are talking about one and the same injustice. But on the legality or on the practical level, so it's a bit different then.
Thank you very much, Mr. Kanyeza. Now we will move to our next question. Okay, the question is from Emily. She asks, what are some examples of modern democratic and creative ways of transferring ownership to communities? Rosalie, would you like to take that one?
Well, I'll take half of it. I think I'd like the others to take the other half. The question itself is difficult for me, because it's also in this transfer mode. The minute you transfer, you're in the replacement mode, transferring to communities, you're entering into a whole new ballgame of governance. And the most important thing, if one does go that route, and we have the Communal Land Rights, the Communal Property Associations Act, so we do have what would be regarded as a modern system here in South Africa. It's been fraught with difficulties because people hold property rights at a family level. They share, land is shared, land uses are shared for sure, and they get there are all sorts of rules that are shared. But the actual property right is mostly held at the family level. And one needs to find a resolution to this dilemma that once you transfer to a collective, how you then rescue the family rights within that collective. And I don't think we have quite found the answer here, but I would like to have the other two have a bash at this as well.
And Nogwanda, what do you think?
Nkanyisa, could you please show me the question again?
It's about what are some of the modern ways in which communities can hold land, or land can be transferred into the ownership of the communities.
Okay, so Nkanyisa, if I'm going to make a controversial point, it's going to be that if we say Black Lives Matter and the way that we exist is validated, Black people know how to hold land. Black people have been doing it for centuries. It can be wrong, it can be right, it can be a learning process. We're dealing with patriarchy, we're dealing with gender dynamic issues, power dynamic issues. But if we're talking about also living customary law as something that evolves and it's alive and it's changing, just that common law will always be alive and changing itself. So we must also understand that when you go to a community, if you say, Olubeni, we want your titanium there on your sand dunes, ask them, as Ipilra states, Ipilra does state what are the customs? How do people dispose of land rights in the community? And if that then informs any sort of way that you will engage when it comes to land rights, it seems as though there's no energy to capture what is already happening in our country. And if we're going to talk about just a blanket ultra act that's going to cover each and every community, the complexity is very, very, it's deep, Nkanyisa. So we have to sort of put those things and be cognizant of the fact that we have histories of desecration in terms of traditional communities. We have desecrations of identity, of livelihood, of dignity, as Ukanyeza has said. So the department will, I mean, I don't want to be sort of the bearer of bad news, but they will fail if this passes. I mean, the committee staffers also did give them 3 options to say this is how we can move forward with the bill. And if they choose to move forward and take it as it is because they're chasing a deadline and not willing to proactively engage and go in depth, I know that they had planned for a overhaul of land tenure framework for this year, but obviously because of COVID, they had some difficulties with implementing and moving forward with it steadily. But those types of things, we need to go deeply and engage that what are we doing with the former Bantustans? Are we turning them into urban areas? When we talk about rural development, what do we mean? What does the word development mean? We need to disaggregate all of these words and make sure that we understand what is the overall picture? What is the South Africa that we are planning on? Are the rural places where people go when they're down and out in the urban spaces? Is it just a place where you have security? Because I have my cows at home, even if something happens to me when I'm in the urban area, this is what I want. But people want development in the rural areas. So we need to have things have been put forward. We have the high-level panel report, which was published in 2017, which has it's a 600-page document. It's quite comprehensive when it's going to talk about how do we move forward with land. We have the Presidential Advisory Panel, which was published in 2019. So there are starting points that the department could consult, but it's just this lack of energy to engage and say, and just facilitate the idea. It's not even the idea, but just knowing that Black Lives Matter and this is the way they matter. And we're going to take whatever it is that exists right now and we're going to implement it for what it is. So in us trying to put something that can't necessarily fit, this is what Rosalie is also sort of moving forward with, is what exists now. Then we move from there. Because now we're trying to make something fit into something else that we're just replicating what the apartheid government was doing. Thank you, Nkanyisa.
Okay, no, thank you very much, Nogwanda. I will just treat that as your concluding remarks because of time. I will ask Mr. Kanyeza to share with us his concluding remarks, and thereafter we have Rosalie, and then we will stop. Thank you. Mr. Kanyeza, any concluding remarks?
Well, yes, I will. I would like to say, yes, we would like to we welcome every support that's going to support our community in the strategy, because yes, it has gone since 1987, since we were removed. So our appeal is to almost everyone is to come on board and assist us. In fact, what we have done is we've been engaged at some level the tribal authority and put it on record to them that we are not fighting them, but we are fighting the injustice. So I think this piece of legislation is also on our side to some extent to help us. And also, I would like to thank you as well for organizing this webinar so that we can amplify the suffering that we've endured as the community. Thank you so much.
Okay, no, thank you very much, Mr. Kanyezi. Rosalie, your concluding remarks?
Concluding remark is, let's stop being so obsessive about land tenure and let's move to a focus on building the institutions around land rights. And that would include customary rights, so that we develop an infrastructure, like a road infrastructure, that these rights can actually ride on. But by focusing so much on tenure, we just get into major ideological fist fights almost. And I think it's the wrong vehicle to actually strengthen tenure. We need institutions to strengthen tenure, not so many more tenure laws.
Okay. No, thank you very much, Rosalie. Thank you to our audience as well. Thank you to you, Nokwanda, and Mr. Kanyeza for joining us. Please join us again next week on Thursday, where we'll be looking at equitable access to land, both as it relates to urban and rural context. Yeah, thank you very much and goodbye.